morning. Thank you all for being with us today. We're thrilled that everybody has been able to join us for virtual meetings, the new norm. About 7-8 weeks ago, I don't think any of us thought this is how we would be meeting, particularly now, considering we're supposed to be at the Skidoo conference in Myrtle Beach. Thought we'd be meeting in person versus via Zoom. So we appreciate everybody who has been able to join us. And I'm going to turn this over to Nick Nicholson, who is the managing director. And I believe you're in the Greenville office. Is that correct, Nick?
That's right, Andy.
And let him get us started. So thank you for joining in.
Great. Thanks, Andy. Thanks, everybody, for having us. Again, I'm Nick Nicholson with Painter Sinker Boyd in our Columbia office. Just before I even start to talk about the firm and introduce myself and Ron, you'll see we have, please, any questions you may have today, please submit them via the Zoom platform. We can answer those during the discussion today. I can assure you it'll make it much more enjoyable if we have an interaction between ourselves rather than just Ron and me talking. Ron and me are obviously wonderful speakers, but it's going to be a whole lot more fun and a whole lot more informative, I believe, if we have some interaction, albeit virtually, among ourselves. So just to briefly, a little bit about the firm and about Ron and me before we get started. So that's our lovely pictures there. So the firm we have between 110, 115 lawyers spread across 4 cities: Greenville, Columbia, Charleston, and Florence. A lot of you know folks in our economic development department, primarily Will Johnson, Frank Davis, and Gary Morris. Also Philip Land is in our economic development group. Many of you also know a lot of our local government lawyers. We practice in areas of public finance and governance issues like we're going to talk about today. And of course, other issues related to local government. We are a full service firm and provide services in the areas of corporate law, commercial real estate, healthcare, financial services, litigation, and tax, and a variety of others. Very pleased today that joining me is Ron Scott. Ron's an associate in our Columbia office. Ron is a triple Gamecock. He has a bachelor's degree from USC, a master's in public administration from USC, and a law degree from USC. Prior to going to law school, Ron had almost a 20-year career in local government. And worked, one of the jobs I'll highlight that he had, he was director of community development for Lexington County. And so tackled a lot of the issues that you all deal with and helping develop our communities and grow our economy. Ron's practice areas are, as you may guess, local government, focusing on public finance. Also has been involved in economic development. Ron is actually involved with the SCADA Institute now. Ron's also involved in governance issues like we're going to talk about today. His other area of emphasis is healthcare. And with regard to that, Ron currently serves on the board of Prisma Health. Like Andy said, I'm the managing director of Painter Sinker Boyd. And when I do practice in the areas of local government, focusing on governance issues, procurement, and litigation. And on the private side, practice in the area of construction law, all the way from preparing construction documents, negotiating those documents, and all the way through dispute resolution, arbitration litigation, if needed. That's a very brief discussion of us. My marketing director, Keely Yates, would skin me alive if I did not mention our website for you to go to if you want to go find out more about us. hsblawfirm.com. We have, I would recommend to you, we got a pretty substantial COVID-19 resource page that I would recommend you to if you have any questions or issues about that. So let's dive in and start talking about the topic today. The primary topic is about meetings, virtual meetings, and how FOIA impacts that, and some other issues that you need to think about when we talk about virtual meetings. But we thought we'd go over a little bit over just some basics of FOIA law, just so we can be grounded in that, and it's going to help inform our discussion. So first, you'll see in the slide, this is a direct quote from the Freedom of Information Act, from FOIA. The General Assembly has said that it's vital in our democratic society to have open government. And so what all that means is FOIA is going to always be construed liberally to carry out its purpose. And again, the purpose is so that the public can participate in its government. All right. And so that's one of the things we need to think about. Here, a lot of times I point this section out to governmental bodies and others who are subject to FOIA as a negative and saying, look, anything you do, you need to make sure you're being extremely careful to make sure that you're adhering to FOIA. In this case, I think it's a positive. I think it's going to give you all a little grace in carrying out virtual meetings, because what you're trying to do is carry out these meetings, but still let the public attend, let the public participate. And so in carrying out virtual meetings, a governmental body is, I would argue, complying with both the letter and the spirit of FOIA in trying to bring the public into their virtual space. Public body is very broad. Of course, it includes all state agencies, municipalities, counties, towns, special purpose districts. It involves many, if not all, of your organizations as well. Any agency supported in whole or in part by public funds or expending public funds. This also includes, this is important, a lot of people don't they forget this sometimes. It includes not only those bodies we just talked about in this definition, but also any committees, any subcommittees, any advisory committees, any sort of subgroup of any of the groups we talked about before may be subject to FOIA. So always remember, if you form a task force, if you form a committee on whatever, it could be, that committee also could be subject to FOIA, and you may have to follow FOIA meeting rules. In that regard, of course, any entity that receives public funds is subject to FOIA. And we're not talking about an entity like us, Haynesworth. We do a lot of work for local governments, and we do receive funds from governments, but we do it for service. It's a quid pro quo basis. The funds we're talking about here are for the general support of an organization in the form of a grant, maybe in the form of other support that's not done on a service or a fee for service basis. The leading case here is a case called Weston versus Carolina Research and Development Foundation. It's a pretty old case, 1991. And there, the foundation at issue received federal grants, it received state grants, it received some money from the sale of some property that University of South Carolina owns. So there, it was really a no-brainer that this foundation was covered by FOIA. The issue comes in is whether, what if a nonprofit has received some governmental money? What does that mean? The Attorney General has said that the question is not whether the entity is supported in whole or in part, the question is not whether the entity is supported in whole or in part by public funds or is expending public funds. It's whether they received it. It's whether they received any public funds for their support. Okay. And Keely, let's go to the next slide. This talks about some. There you go. So the Attorney General has said that FOIA does not discuss support in relative terms, and so the AG has offered that FOIA contains that it can be just a small amount of money and you're hooked in by FOIA. I don't know if that's true. That case hasn't really been litigated or decided. But for folks like you who if you already receive public funds and you're subject to FOIA, that's probably why you're participating here. But you may form yet other nonprofits that flow out of your organization. So you always need to be very careful about the types of funds that go in to support your organizations. I would say now, if you take the position that you're not subject to FOIA, continue to do that. But always remember that if you have somebody who is out there that you may indeed be subject to FOIA, and as much as you can still comply with FOIA, but still say, well, I'm just doing this to because we have nothing to hide. That's not a bad tack to take. I do want to, we're talking about meetings, but I just want to mention very briefly about deadlines, because it's a tip you may have if you receive requests for documents. Of course, under the law was amended a couple of years ago now that you have a public body body subject to FOIA has 10 days to respond to a FOIA request if the records are 24 months old or less, 20 days if they're older than 24 months. It used to be 15 business days, now it's changed. Of course, Saturdays, Sundays, holidays are excluded. If you're not going to charge fees, you've got to provide documents within 30 days of your response. If their documents 24 months old or less, and 35 calendar days from the request if they're older than 24 months. Now, let's go to yes. I would recommend you always charge a fee, even if it's just a nominal amount. I think that's a good practice. And the reason you should charge a fee at the very least is because that's when your date to provide actual material starts to run from the date you receive the deposit. You can only charge 25% of the estimated cost, and the costs have to be reasonable, and they have to be they have to, that's really beyond the scope of what we're talking about, but they have to be reasonable cost. But if you do charge a fee, you have 30 days to provide documents after receiving the deposit if the documents are 24 months or less, and 35 days, 35 calendar days. Now remember that calendar days, not business days, calendar days of receiving the deposit if the records are older than 24 months. This is why I bring all this up, given where we are now. A lot of you are working remotely. A lot of you are scattered hither and yon. You may not be in your offices. It may be more difficult to gather documents, to gather materials. I would recommend that whenever you make your initial response, or just call them first and let them know, hey, we've got your response. We're working on it. As you know, we're in a different time, or we are working remotely. Our offices are not fully staffed. Whatever the actual case is, let them know, establish the record right now that we are in a different time, and just so that because it may actually take more time, and people now are going to give you a little bit of grace, I believe. I know that from some of the local media have been a little more lenient, have given more time, given where we are now, because if push comes to shove and somebody goes to a judge and says somebody's being delayed, the courts even today are going to be a little more lenient. So just remember to let people know that these are different times, and because of that, you're asking for a little more time to respond to the request. All right, let's talk about meetings. That's why we're here really today. Of course, any meeting of a public body or body that's subject to FOIA, like some of you are, must be open to the public unless it's closed pursuant to the executive session provision of FOIA, which is 30-4-70. Meeting means the convening of a quorum of your body, whether corporal or by means of electronic equipment. So you see there, FOIA, by its very terms, anticipates and allows for virtual meetings. And that meeting means to discuss or act upon a matter over which the public body has a supervision, control, jurisdiction, or advisory power. This is especially important today when we're talking about virtual meetings, and it's also important given the ease by which we can communicate nowadays. The FOIA states that no chance meeting, social meeting or electronic communication may be used to circumvent the spirit of the act. So in other words, you can't just get on a call. Hey, let's get on a real call real quick and talk about this issue. Here's a number we can all call. Let's go. It will only take 5 minutes. Let's go ahead and call and knock this out. You can't do that. That violates FOIA. This talks about a chance meeting. My guess is there's not much chance of you all running into each other accidentally now at the local Chick-fil-A or anything and starting the meeting, because the local Chick-fil-A is not open. But it certainly is something that could happen electronically. I would also caution you all to not make any decisions via email chain. That could also run afoul of FOIA. I'm going to highlight one case before I turn it over to Ron. This is a very recent case that came out of Somerville, and here what happened was the Somerville conducted some workshops to look at some design criteria for development that was going on. The architect came in and we showed plans to 2 or 3 members of the board in just sort of workshop fashion, and they on purpose did not have a quorum, and because they didn't want to run afoul of FOIA, so they did the right thing there. The plaintiff in this case sued and said, yeah, but they really are meeting, even though they didn't have a quorum on purpose. They use this to circumvent FOIA and to get around the requirements of FOIA. And the court said, not in this case. It said they really were just having workshops and looking at plans, and the settings that they had were fine. But the court did warn that workshops should not be used as a way to circumvent FOIA. So just remember that it is fine to get together with if you don't have a quorum to do some things like this workshop that they're talking about here to accomplish some other things. But really, if you're going to try to split the meeting up so you have different people talk about a specific matter and then you make a decision collectively or off the record later, that may run afoul of FOIA. So just remember to always follow the spirit of FOIA with respect to meetings. I'm going to turn over to Ron now, who's going to talk about how you call a meeting and some things we're going to look at for carrying on a virtual meeting. Ron.
Thank you, Nick. Good morning to everyone. We appreciate the opportunity to talk with you about FOIA and its impact, especially in this age of so many virtual meetings taking place. I want to talk a little bit about FOIA requirements as relates to notice of meetings. FOIA specifically requires that if you have regularly scheduled meetings, so at the beginning of the year, if you have a schedule of meetings that will take place each month at a specific date or time, that information must be published at the beginning of the year, the date, the time, and the anticipated place or location of that meeting. You should share that publicly. You should share it with local news media and with any persons who have expressed interest in attending or finding out information about what's discussed by your particular entity. As relates to your specific meetings, FOIA also requires an agenda that sufficiently describes whatever matters will be discussed, decided upon, or acted upon by the governing body. And that agenda must be posted at least 24 hours in advance. And I do want to say that even though the requirement lists a minimum of 24 hours in advance, the law also says it's certainly good to do it much sooner than that if practicable. And I think most of you probably would comply with that by posting your agendas several days in advance of your meeting. But the law requires that the agenda must be posted on your bulletin board at your regular place of business if you have an office location that's open to the public, or at the meeting location if you don't have a principal office that's open to the public. But also it requires that your agenda be posted on your website if you do have one. So that's an important point to be sure that when you're complying with the deadlines for posting the specific agenda for each individual meeting, that you ensure that it's posted at a physical location as well as on your website. And that applies to regular meetings, special call meetings, etc. This particular notice requirement does not apply to emergency meetings. There's an understanding that there may be things that come up that require an emergency calling of a meeting. But as much as you can comply with, even in that instance, the spirit and the intent of the law, that is appropriate. Moving to the next slide. From the standpoint of written notice of your meetings and the agenda, you do want to be sure that any persons who have expressed to you that they want to be on the regular list of persons to receive your agenda, whether that be the news media, certain organizations, or just individuals who have called and expressed, we would like to receive your agenda information or information about your meetings. It's good if you have a secretary or someone who's responsible for posting that agenda, that they may perhaps keep a running list of those persons, so that upon you're preparing your agenda or notice to be sent out, that information can be sent to that list of persons. And I think it's very important that you should note that your minutes should reflect that in your meeting, the presiding officer asked about compliance with the posting and notice requirements for you, noting in your minutes that it has been affirmatively stated that persons who have requested information, the news media, et cetera, were noticed and did receive information as pertains to the meeting. As we transition to the next slide, in the age of the COVID-19 pandemic, virtual meetings have become the norm. I don't think any of us foresaw all of the circumstances that we've dealt with this year that have prevented gatherings and meetings as we normally would. But the business of government and the business of conducting business as pertains to economic development matters and other matters of importance has to continue in spite of this pandemic. And you've seen a number of entities look at meetings by conference call. You've seen some video platforms like WebEx and even Zoom, as we're using today, used quite frequently to conduct these virtual meetings. One point that we want to be sure you consider as you think about virtual meetings is make sure your bylaws allow for electronic meetings. It's always good to take a look at your bylaws to be sure that they're up to date and that they reflect your operations or your procedures. But in this day and time, it's a great opportunity for you to ensure that if you do conduct electronic or virtual meetings, and sort of a hybrid where you have some persons who are gathered together for a physical meeting, but allow some members of the governing body to participate offsite via virtual means, be sure your bylaws do allow for that type of meeting. It's a good opportunity to dust off those bylaws and take a good look to update them. From the standpoint of virtual meetings, you also want to consider some protocols that will allow for good flow of your meeting and an identification of everyone who is involved. We recommend that you require all of your attendees, if you're conducting an electronic meeting via WebEx or Zoom or whichever platform you use, require the attendees to dial in through the computer rather than just by a phone call-in number. That allows you to identify the participants who are present, and it also allows for the continuity of the experience. Callers may not necessarily be able to see, obviously, the information that you can see as we're displaying today, the PowerPoint of this particular presentation. So connecting to the meeting through the platform of dial-in for the computer, I believe, is a great opportunity to create that same experience for all attendees.
Hey, Ron, can I make a comment here?
Sure.
So there may be some, and I agree completely with what Ron said about having everybody, if the meeting is going to be conducted by Zoom, everybody dial in by a computer. They can also dial in by phone too. There's that audio option for Zoom, but they need to go in first through the computer. And so some may argue, well, that's not fair. I don't have public access because I don't have a computer. I don't, or for whatever reason, or I just want to do it by my phone while I'm driving somewhere. And so they may complain and say, you're not being as open to the public as you can. The response would be, says, well, this is the way we're meeting, and this is the way we need you to do it. It's no different than if you're meeting in a physical location and someone can't get there for a particular reason. Maybe they don't have a car, maybe they just can't get there in time or whatever. And so you get to choose the way you conduct your meeting. And as long as other people have ready access or have the same access that you're using, we think that's fine. And so just be ready for that type of argument, that people should be able just to call in, and you do have some means and some legitimate reasons to say, no, this is the way we're going to do it. And you can dial in and certainly join us the way we're going to conduct our meeting. Sorry, Ron, go ahead.
Thank you. Very, very good point. As we transition to the next slide, talking about protocols for conducting virtual meetings, it's important, as we talked about, considering your bylaws and what they may stipulate as to how you will conduct virtual or electronic meetings. I feel it's important that you consider some protocols for the smooth operation of those meetings. And you may even consider reducing those protocols to a resolution on how you will conduct your virtual meetings. For example, we'll get to minutes later in the FOIA requirement for minutes, but from the perspective of documenting all of the members of the governing board or body who are attending the meeting, it's a great practice to have an initial verbal roll call of all participants of the governing body. Maybe have your secretary or presiding officer, or however you determine, do a roll call of who all is present on the meeting by going down the list of all the members of the governing body and asking them to respond that they're present. Great opportunity to document that they are on the call and that you have a quorum at the initial beginning of the meeting. Also thinking about, in the age of virtual meetings where we're not physically together, how do you identify that you wish to speak or to address an issue? It certainly can be very chaotic if everyone is trying to talk at the same time and you can't identify who is talking. It may be a good procedure to consider that all participants of the meeting be muted other than the presiding officer, and that you establish a protocol. Zoom has an opportunity where you can raise a virtual hand to speak, requesting to be recognized by the presiding officer, and it allows for an orderly flow of communication. It also allows that every member who's participating in that meeting can be heard if they desire to speak. And it's a very easy opportunity to identify that you wish to speak. Also, if there are public participants who dialed in or who are calling in, it's very important, I think, to mute all participants, or if you choose to allow your members of the governing board not to be muted, but certainly to mute all participants who are just viewers or observers, so that your meeting would not be disrupted, and that all persons can participate and hear the flow of business as would take place as you would envision for an orderly, even in-person meeting. Relative to votes that are taken or action items, I think it would be very important when you're having an electronic meeting to consider roll call votes. In some instances, when physical meetings take place, there is a collective, perhaps all in favor expressing aye or all opposed nay. You aren't able to do that in quite the same fashion with an electronic meeting, and it's much more orderly if you have a roll call vote for each individual, allowing them to individually express their vote in affirmation or opposition to whatever is being considered. Also, even consider allowing a vote by email. If you have some issues with audio or video transmission, certainly internet access is not always guaranteed to be spot on, so that's an opportunity to do so. And even on the back end of that vote, having the presiding officer or the secretary reaffirm the vote that has been taken by each particular member, so that if there's any discrepancy, etc., you've got on the record what has been documented by whomever is taking the tally of the meeting and votes. In terms of public meetings, there are opportunities for executive sessions, and we'll go into a little more detail on what FOIA allows as pertains to executive sessions. But executive sessions can be a bit more challenging in the context of public meetings that are conducted virtually, and it will require some planning. For example, in Zoom, as we're using today, Zoom has some features that allow for separate rooms, virtual rooms, where, for example, members of a governing body could participate in a private discussion that is secluded from the public to address those matters that are allowable under FOIA. And you would want to have a technological person who is able to ensure that you're not recording those particular executive sessions, that you have properly secluded your governing body to be able to have that protected discussion. You may even want to consider a separate conference call-in number where you put the general meeting on hold, but your members of the governing body can call in on a separate number to conduct that executive session. And from the standpoint of documents, certainly just be mindful and careful about the documents that you send out, and even things that you put in your packets that are distributed from the standpoint of privileged information, how you would want to protect that in the context of an executive session. Public
Ron, let me make one comment on the privilege.
Okay.
Especially if it's a matter that you're dealing with an attorney, for instance, your lawyer, and it's attorney-client privilege. You have to be very careful about who gets that information. Members of the board obviously can get that information. The board is the entity, so to speak. But if you include somebody else, maybe a third party, maybe a vendor who's involved in a contract negotiation or whatever, and you include that's a bad example because you have contracts that you can talk about in executive session. But if it's something else and you include a third party, you can waive the privilege. And so just be very careful about sending out, about who your audience is when you send out materials in advance of an executive session.
Very cool. Thank you, Nick. Public comment periods and public hearings are taking place even now in the context of virtual meetings, and there are some important considerations that need to take place to conduct those public comment periods and public hearings, especially in the context of economic development projects that may require public hearings for approvals of ordinances that might relate to governing municipal or county councils. Certainly they will have their protocols for conducting those, but we just wanted to cover some good best practices as relates to public comment periods or public hearings in your virtual meetings. Your meeting agenda should provide guidance on whether there will be a public comment period or public hearing, and how an interested party or member of the public can participate in that public comment period or public hearing. You may want to note on your agenda that if persons desiring to participate should contact a specified person by a certain date. Or you may, if you are collecting comments via email, as I've noticed some jurisdictions are doing, provide that email address in advance and give a deadline by which public comment must be received. In that context, we also think it's a good best practice, if you do receive those types of public comments, maybe have someone read them into the record of your public meeting. So that you can document the comments that have been received, and all members of the governing body have a chance to hear and digest that at the same time. In the context of public hearings where someone is actually speaking on a particular matter for consideration that's perhaps required, there have been some examples of Zoom being used to create an orderly queue of persons in line to speak. And you'd want to certainly coordinate with whomever your technological person is, a sign-up period, having a sign-up period for persons who wish to speak, an orderly notice for that person who desires to speak after they've identified themselves or listed their name or contact information, providing that information to the presiding officer so that they could orderly recognize whomever is speaking and document that as would take place in a physical meeting in the minutes. For example, we have Ron Scott, who has expressed an opportunity to speak on matter X. Ron Scott, you will have 60 seconds or 2 minutes to speak on this particular matter, and have your technological person ready to unmute that particular presenter or speaker. It's a great opportunity. You certainly would want to coordinate that, because certainly that can present a number of challenges from an IT perspective. But these are just some considerations for what you can do as it relates to public comments and public hearings. We don't recommend public comments if they're not scheduled or listed on your agenda. General public comment periods, especially in the age of virtual meetings, can certainly be very difficult and chaotic. So if they are not listed on your agenda or planned for, probably is not a good practice to do so. And again, requiring any persons who desire to speak to identify themselves ahead of time and register or sign in to speak. And again, if there are public hearings being conducted before municipal or county councils in relation to any project you're working on, I'm sure they will have procedures or protocols that will need to be followed. But these are just some of the considerations that you may want to have in the context of public comments or public hearings. And I think we're going to talk about if there are any opportunities for questions. I know Nick and I have talked a good bit about a number of.
Yeah, Ron. So we have folks who have, and these are some examples we've seen with other people conducting virtual meetings. And one example I've heard is that somebody, a member of a town council was speaking during a virtual meeting, and someone from the public was writing some comments, typing out some comments as this person was speaking, and saying not some very nice things about the person, about the things that this person was talking about. And so it leads to a couple of considerations. Number one is that you have to be prepared for that. In a public meeting, or at a normal meeting where you're all together, those types of comments while you're speaking simply would not be allowed. FOIA would allow you to call that person down. If that person did not stop talking, you could literally have that person removed. FOIA allows that. Here, someone typing out comments is not really so disruptive where you would be able to, I think, to just shut them out of the meeting. But you have those comments nonetheless. Now, if those comments could be seen by everybody, and certainly if they were vulgar or just perhaps they were racist comments or some other sort of prejudicial comments, then probably you could delete that person from the meeting. I think you could do that then. But otherwise, I think you need to let the people vent. I would recommend strongly not responding to somebody like that, and just if they want to do that, go ahead. But those are things we have to be cognizant of and ready for in this new world when we're meeting virtually. So hopefully that'll never happen, but just always something to keep in the back of your minds when you're having these virtual meetings.
Right.
Okay. You just want to move on, Ron?
Sure.
Keep on with agendas?
Sure. We wanted to reemphasize in the context of meeting agendas that the age of virtual meetings does not change any of the requirements to have an agenda and to post that agenda. Again, the posting at your physical meeting site, if you are having one, is important. And we do recommend, for example, even if you are not having a physical meeting on site, if there is a regular place of business where you're meeting that is closed to the public, maybe a good practice to consider posting your agenda and notice of that meeting on the outer doors of that location, in addition to the requirement to post on your website. Just an additional opportunity to satisfy the spirit of FOIA so that the public understands and has notice of a meeting and that matters that may or may not impact their particular concerns are being discussed, but they have the opportunity to be aware in advance. Amending of an agenda is an important consideration as pertains to FOIA. Once your agenda is posted and you've satisfied the initial requirements of FOIA, there are opportunities to amend an agenda, but that amendment process preferably should be done in the same fashion as was done to post your initial meeting. For example, if you want to add an item to the agenda that was not included in the original posted meeting, and you have taken the advanced planning to post your agenda well in advance of the 24-hour period, it would be acceptable to post an updated agenda in the same fashion and to send that updated agenda out to the same persons, entity, news media outlets, et cetera, that you typically would have noticed for the first agenda. So again, posting it at your place of meeting on your website and sending it to any interested parties at least 24 hours in advance. And then the question may come up, well, what happens if you don't have that period of time and you have a matter for consideration? FOIA does allow for an item to be added to the agenda at a meeting that has not been noticed in that 24-hour period, but it must be approved by a 2/3 vote of the members of the governing body who are present at that particular meeting to add that to the agenda. It's also important to note that if that item on the agenda is an item of a final decision or an item that the public would not be able to comment upon before a final decision is taking place, then you need to have two things satisfied, and that is the 2/3 vote of the persons or the governing body who are present to actually add the item to the agenda. But also you need to have a finding by that body that failure to place that particular item on the agenda in a fashion of adding it during a meeting will create an emergency, or as the law defines, an exigent circumstance. And that's a pretty high bar. You need to be able to show very specifically that you could not, but for that particular item being placed on the agenda, avoid an emergency or situation or exigent circumstance. And the intent there is that FOIA is a law intended to shed light on anything that's being addressed in the public realm or any entity that's governed by FOIA, as Nick described earlier. And you want to have adequate notice so that any interested person, party, or even the news media who would like to be present or to provide comments even to the council or governing body or whatever that may be ahead of time will have an opportunity to do so. So think about that as you have any opportunities or considerations to amend an agenda. If it's something that can wait until the next meeting, it's probably good practice to do so unless there is an emergency situation.
Yeah, and remember, if you're meeting virtually, it's going to be very easy to get back together.
Yeah.
And so there's really no reason to risk it, is to just go ahead and just notice a meeting for another 24 hours and have your meeting again.
And moving on from the agenda to minutes, FOIA does require that any entity covered by the law must keep minutes of your meetings. And minutes are a documentation of the date and time and place of the meeting, who was present at the meeting, members of the governing body who was present, who was absent, and the substance of the matters proposed, discussed, decided. And it doesn't have to be a verbatim transcript of every word that's stated, but certainly a sufficient documentation for the record of any issue, discussion, and especially votes taken. It's important as pertains to votes that your minutes document persons who, whether it's a motion made or seconded, or persons who voted in the affirmative or in opposition to a particular item. It's important to document those things for the record. And any other information that any member of the governing body decides should be included, whether that be attachments or information presented that would have been a part of the discussion or the reasoning behind a particular decision made. It's certainly fine to include those in your written minutes of the meeting. It's also important to note that as relates to publishing your meeting minutes, they don't have to be published immediately. There was a case, as noted here on the screen, that addressed that particular issue. And most governing bodies have a practice of, after a meeting takes place, whomever the secretary or scribe is, will put together those meeting minutes and will send them out to members of the governing body for review and approval, likely at the next or maybe even the second meeting thereafter. And then once those meeting minutes have been approved by the governing body, they then are made available to the public. And that's certainly a permissible process and certainly a good process to ensure accuracy. And I've had some instances when I worked in local government when you're dealing with so many different issues and votes that come up or matters under discussion that you could have a mistake even in who made a motion or a second, or maybe incorrectly transcribe someone's vote. So it's a good opportunity to be sure your official record of your meeting, which is in the form of minutes, are correct and accurate and have a chance to be reviewed and approved. It's just a good practice. I've had instances where I've had to deal with even the minutes being subject to expiration and litigation. So you certainly want to be sure they're correct as reflects the discussion and deliberative process for your meeting.
Hey, Ron, we've got a couple of questions I was gonna answer here.
Okay.
We're getting close to the hour. So one question was, are these materials available? And the answer is, of course. Anybody who wants these materials, just you can let Keely know, or Andy, or Ron, or me. Be glad to send you copies of these materials to have and to review. The next question that was asked was, do the requirements that we're talking about, do they apply to public-private partnerships? The same discussion that we talked about earlier about non-public bodies who receive public funds, that applies to a public-private partnership too. And the question on whether an entity receives public support such that it is subject to FOIA is very fact intensive. And so it's when thinking about those issues, it's important considerations are how the public-private partnership gets set up, where's it being housed. For instance, is the office of the public-private partnership, is it housed in, say, a county building? That right there could be deemed to be public support, such that the public-private partnership is subject to FOIA. Is the public-private partnership, or is it being staffed in part by some governmental bodies part-time? That could lead it to be deemed to be a subject to FOIA. There's just a bunch of different factors to look into as to whether or not an entity is subject to FOIA. And frankly, there's not much law on it. I mean, there's a lot of attorney general opinions that I think, quite frankly, go too far. And there have been some recent cases where you would have thought that maybe the entity would have been covered by FOIA, but was not because of some specific circumstances involving the entity. One example was some state chambers, or excuse me, some chambers of commerce that weren't subject to FOIA because of some other laws that the Supreme Court said trumped FOIA. And so it's hard to give a blanket answer on whether a certain type of entity is covered by FOIA. But again, it's factually intensive, and the thing you have to look at is the public partnership getting public support for really no goods being offered back to the entity. And so, but if you are subject to FOIA, and if you do receive public support, then the whole litany of FOIA applies. The requirements regarding meetings, regarding taking minutes, regarding document production, it all applies. So if FOIA is applicable, you got to follow the whole thing.
Very important points, Nick. Were there any other questions that we have at this point? That
I don't see any. I think we've got just enough time, Ron, for you to go over executive session, which is always good to get a primer on.
Certainly. FOIA does allow opportunities for executive session or closed discussions that are shielded from the public in the context of specified matters that are detailed very specifically in the act itself. And in the interest of time, I think we have a slide here that lists, if we could maybe advance just to slide 38, because it shows all 5 of the items that the law specifies. One is the discussion of employment-related matters or appointments or personnel decisions as relates to an individual, et cetera. Discussion of negotiations related to proposed contractual agreements, proposed sale or purchase of property, and matters related to legal advice or attorney-client privilege. Discussion regarding security personnel or devices, criminal misconduct matters. And 5, which is certainly very common in the economic development world, are proposed expansions or relocations of prospective business projects or industries. It's important to note that items 1 and 5, when going into executive session, FOIA requires that you announce with a good bit of specificity the reason that you're going into executive session. Certainly not detailing all the matters that will be discussed, but announcing with specifics that you're going into executive session to discuss X, Y, Z, and not be general. But for item number 1, which relates to employment matters, appointments, personnel decisions, and item number 5, the law does allow for a very limited disclosure of the names of persons or the names of entities, just realizing the sensitivity of those particular matters, especially in the economic development world. I think creative names are always used when a project must have confidentiality because of negotiations that are taking place or business concerns related to a particular entity that you may be working with or that's under consideration. So that's a common practice. But for matters 2 through 4, there should be a good bit of specificity, probably erring on the side of caution to be sure that you describe in sufficient detail those particular matters that are going to be addressed in executive session. And it's important to note as well, when you are in executive session on a matter, action cannot be taken during executive session, and there should not be polling of persons, even if we call it informal polling. There shouldn't be informal polling of persons on the governing body about how they will vote on a matter. Executive session is meant to discuss those matters in a protected manner. But then if action is to be taken on those particular matters, just as you would when you go into executive session, you would want to have the presiding officer call for a vote that would affirmatively approve or deny the request to go into executive session. You would then come out of executive session to take action on a particular matter. So that's an important point to consider. I think there have been some instances in the past where entities that I'm even aware of have taken informal polls or voted or deemed it that they've taken the actual action in executive session, and that's not permissible to do so. So that's an important consideration there as pertains to executive session matters. Nick, as we round out here,
let me just make it. We've only got time to handle one more item. And Keely, if you go to slide 47, so it's always something I like to point out to folks is that this is a case called Quality Towing versus City of Myrtle Beach, and the long and short of it is that a committee of your organization may in fact be subject to FOIA. We talked about this earlier about the definition of a public body, but not only your body itself, but if you have a committee, it may be subject to FOIA. And Quality Towing, the committee that was formed was simply an advisory committee that was tasked to look at some bids regarding some towing services and to just advise the city manager. The city manager was the one who actually made the decision on who to award a contract to, but the committee met and gave some advice, and the Supreme Court said that was improper, and they kicked it back down to the lower court to consider what if anything needed to be the remedy. And so and you can drive yourself crazy in thinking, okay, well, what is a committee? If just three of us are going down to the coffee room to talk about something, have we formed a committee? Well, probably not, but there's something you always need to keep in mind. If you certainly form a group and you give it an official name, then you may have formed a committee, and you may need to post a meeting notice of that so that people can join you. Now, there's certainly, if it's something your committee needs to do in executive session and in private, you can always go into executive session the minute you start meeting. But this is something for you all to consider when you form a committee of your group to talk about things. The meeting requirements may in fact be subject to FOIA. Again, it's very fact specific, but it's a provision of the law that's been out there a long time, and a lot of people sometimes forget about it. I think our hour's about up, and I don't see any more questions. Andy, anything else to add, or have you seen any questions?
I do not. And if anybody wants a copy of the presentation, please email me, and I'll coordinate and be happy to share this with you as well. And Nick and Ron, thank you so much for doing this. We've gotten a couple questions since everybody started meeting virtually, and you answered a lot of the questions that I have been asked, and we really greatly appreciate you taking the time this morning to.
If anybody has any questions, Andy, after the fact, feel free to call Ron or me, or take them through you. We'll be happy to answer them offline.
Perfect. Well, we greatly appreciate it, and thank you to everybody who joined us this morning. I hope this helps you as we navigate our new meetings in the virtual world. So I hope everybody has a great rest of their day. Thank you.
Thank you.
Thank you.
Thanks for joining this webinar presented by Hainsworth Sinclair Boyd. To learn more about the firm and its services, visit hsblawfirm.com.